Sam Seder, Emma Vigeland on the Majority Report. Real pleasure to welcome back to the program Mark Joseph Stern, senior writer at Slate. Mark, welcome back on a week. I should just note that we're probably going to see the confirmation of the 200th member of the federal judiciary, which is about 7 more than Donald Trump had. Of course, Donald Trump had 3 Supreme Court justices to appoint, and Joe Biden only 1. But at the very least, there's been some balance. The Biden administration done a much better job with judges than the Obama administration did. But yet, here we are.
Definitely better than the Obama administration. The Biden administration has not gotten as many judges on the courts of appeals yet, which is an issue because they are so powerful and decide the majority of cases. You know, most cases don't even get to the Supreme Court. But that's in part because a lot of conservative judges are timing their retirements more strategically than left-leaning judges. And Trump got to flip a number of seats because left-leaning judges on the courts of appeals stepped down to often take big law firm jobs because they wanted to put their kids through school. And conservative judges don't do that under Democratic presidents.
I think it's just a little bit more than just putting them through school. I have a feeling when you get those jobs, you're also getting a pool and more. But be that as it may. And also, I got to say, it's also a function of the types of people who were chosen to be judges under the Obama administration, or frankly, in those prior Democratic administrations, a lot of corporate judges.
Absolutely. A lot of corporate judges, a lot of prosecutors who all sort of expected to be making the big bucks at this stage in their lives. And of course, federal judges make a few $100,000, not the millions that a law firm partner does. And so I agree, this was a huge problem with a lot of Obama's appointees. You know, some of them held out till Biden and stepped down in their 50s under Biden, which is fine. But I think we'll see a very different pattern with some of Biden's judges, most of Biden's judges, because when you're drawing from public defenders, civil rights attorneys, voting rights attorneys, these are folks who know how to make a good life with a few $100,000 a year in salary. They're not going to cut and run because they need an expansion of their house or another pool or whatever. And I'm optimistic that more of Biden's appointees will serve long terms and cling on under the next Republican president and make a stark distinction with some of Obama's rather corporate prosecutors.
Yep, I hope so too. All right. In the meantime, one thing, or at least, one of the things that was good that came out of the Obama administration in the Dodd-Frank which didn't really go far enough as far as some of us are concerned. But one of the good things that came out of it was the Consumer Financial Protection Bureau, which was actually sort of like Elizabeth Warren's baby in some ways. And one of the things that was unique about the Consumer Financial Protection Bureau to insulate it from politics was to make sure that it was funded by fees it was collecting from financial service entities and through fines. And this was the grounds in which it was attacked. And it's been, what's amazing is I feel like this is such a repeat.
So it actually draws most of its money from the Federal Reserve, which itself collects money from interest on securities. So it also does collect, of course, fines and fees. That's its main enforcement mechanism. But yeah, I mean, the CFPB has been under assault since the day it was created, and the Supreme Court struck down a small part of the law that created it in 2020 by holding that the president can fire its director. As Elizabeth Warren created it, it was supposed to have one director who served a 5-year term, and the president couldn't fire the director unless they did something really, really bad. The Supreme Court struck down that protection, which ironically ended up benefiting Joe Biden more than anyone else because he was able to fire Trump's terrible CFPB director on day one and install progressives to lead it. But this is the other part of the attack, which is this idea that because the CFPB draws its money primarily from the Federal Reserve, it's unconstitutional. Now, just to hear that sentence, you might be scratching your head and be like, what could possibly be wrong with that? A bunch of payday lenders and their lawyers at Jones Day, the law firm, concocted this theory that federal programs and federal agencies have to be regularly funded by Congress in a bill that's stamped with the word appropriations. And that if Congress chooses to fund an agency any other way, including the way the CFPB is funded, it's unconstitutional and must be struck down in its entirety. And I just want to be clear, these groups, these litigants and their lawyers, they shopped this theory to 7 different courts, which all turned it down, basically laughed it out onto the street, before they landed their case at the Fifth Circuit and found a willing audience at the Fifth Circuit, which struck down the entire CFPB, which led to this decision. So it's another good example of how these litigants will just go shopping to court after court until they find one, usually the Fifth Circuit, that's crazy enough to bite. That's what happened with a lot of Joe Biden's vaccine mandates, and it's what happened here.
If someone was to do a word cloud of every conversation that we have had on this program for the past 4 years about legal cases, the biggest 2 words would be in huge bold Fifth Circuit. And
then administrative state after that.
Yes. And then Chevron probably.
Yes.
Doing the Lord's work, trying to get people to care about the administrative state. I appreciate it.
Well, but the Fifth Circuit, I mean, this is so messed up. And then I guess the other one would be me mispronouncing that Judge Kaczynski or whatever his name is.
Kaczmarek, who is within the Fifth Circuit.
Within the Fifth Circuit.
There we go.
But before we get to just that one point, I just want to say the first thing that popped out for me, and I think Kagan ended up bringing this up, was that's how Social Security is funded. Like, Social Security is non-discretionary spending, which means that every year there is no word appropriations for Social Security because Congress does not appropriate money from the general budget to Social Security. It is its own self-funding mechanism. They may have to raise the taxes at one point to get it to refund the trust fund, but Social Security cannot add to the deficit. It is not part of the yearly budget, and that's like the half of the government.
So Social Security, Medicare, Medicaid, pretty much every other financial regulator, including the Federal Reserve and the FDIC, a bunch of other agencies going back to pretty much the 1790s. All of them are funded in ways different from how the Fifth Circuit said everything has to be funded. The Fifth Circuit made up this theory out of whole cloth and essentially declared that trillions of dollars worth of spending and many, many, many parts of the government itself are simply unconstitutional and have to be struck down, sort of destroyed by judicial fiat. I think the good news is that the Supreme Court rejected that by a 7-2 vote. The bad news is that it even got to the Supreme Court in the first place because of the Fifth Circuit's total insanity and depravity. And of course, that 2 justices still saw fit to dissent and attempt to, we can talk about this, basically trigger a recession that would have destroyed the country.
I want to talk about that part of the 2, but walk us through, because maybe this is a good time to illustrate why the Fifth Circuit. Like, how does our federal judiciary system, like, how does the Supreme Court get cases? And also, what happened to the attempt to stop the judge shopping? I mean, I was under the impression that the federal judges had got together and said, we're going to stop this judge shopping thing. And then it turned out to be more of like, we think that people should stop judge shopping.
Yeah. So for your second question, that's basically what happened. There was a rebellion amongst the judges who like being shopped to, people like Matthew Kaczmarek, when the Federal Judicial Conference said we're going to curtail judge shopping. All of these guys in the Fifth Circuit and the district courts within the Fifth Circuit said, absolutely not. How dare you? This is outrageous. Did like a full court press. And so the Judicial Conference ended up sort of walking that back and urging individual courts to adopt these new guidelines, which many courts did not, including the Northern District of Texas, which is where Judge Kaczmarek and many other wackadoodles sit. And so we are still dealing with this problem. Of course, this case originated years ago, so it wouldn't have been directly affected by this. But there's more that the Supreme Court can do. And one thing it can do is, in cases like this one, add a note at the end saying, by the way, we see how egregiously engineered this case was to be placed before the Fifth Circuit for no reason. And part of our decision is rooted in our disgust with how the lower court here manipulated the rules to help the litigators. Of course, the Supreme Court didn't do that because they're still cowards and they're afraid to tackle this problem directly. But it's continuing to boil. And it's something worth keeping an eye on because the court does have other tools. And of course, Congress could step in at any time and fix this, but Republicans don't want it to.
Okay, so walk us through, for people to understand how our federal judiciary works, because I said 200 judges, you said not the circuit court because we were talking about the federal district courts. And what's the difference? Just walk us through the different hierarchies and how a case makes it to the Supreme Court.
Yeah, so for the vast majority of cases, a lawsuit or complaint is filed in a federal district court. The federal district judge in that court gets to oversee the case, issue a decision. In theory, cases are supposed to be randomly assigned to these judges. By law, in fact, cases are randomly assigned to one judge on the court. So even though it's called the Northern District of Texas, for instance, that's one court, it has a bunch of different judges who sit on it. But what these judges have done is put themselves in what are called single judge divisions. So they'll set themselves up in places like Amarillo, Texas, or Wichita Falls, Texas, where they are the only federal judge in that geographic area. And they will invite litigators to walk into their courthouse and file a case, which is then not randomly assigned to any judge within that district court, but assigned directly to them. That is what Matthew Kaczmarek keeps doing. He just recently, by the way, blocked the new law that Congress enacted and directed Biden to implement that closed the gun show loophole. So this is still very much happening. Whatever that judge does, it then gets appealed to the Court of Appeals that oversees those courts. So here for Texas, Louisiana, and Mississippi, that is the Fifth U.S. Circuit Court of Appeals. The vast majority of cases, something like 99% of cases, they end at the Court of Appeals, right? The Supreme Court is lazy. The Supreme Court only takes like 60 cases a year. Even Brett Kavanaugh says that that is a ridiculously low load, and he's right. So most of these cases are just ending at the circuit courts. And the circuit courts, therefore, get to make most of the law in the country. Even if a circuit court gets it wrong, it might not be a decade, even 20 years until the Supreme Court steps in to reverse it. The Supreme Court can take its sweet time. So this is how we
just
get
to be clear, you could have one set of laws essentially in the Fifth Circuit.
Correct.
And another one in the Eighth Circuit or the Fourth Circuit.
Correct. And that is when the Supreme Court's supposed to step in. We call that a circuit split. But again, the Supreme Court has gotten kind of lazy or gun shy or something, and it hasn't been resolving those splits. So we have very different law in different parts of the country. And that is especially true when it comes to immigration law, because the Ninth Circuit oversees California, and it's very liberal, and the Fifth Circuit oversees Texas, and it's extremely conservative. So basically, migrants who come in through Texas have a much lower chance of being able to vindicate their rights under law, like the right to seek asylum and have a credible fear of persecution hearing if they come in through Texas than in California.
And we should say the reason why the Fifth Circuit, Texas, Louisiana,
Mississippi,
and Mississippi versus the circuit, the California circuit, is because the senators from these states nominate these people to the that court, and if they don't want, if they have a problem, or they suggest, I should say, to the White House then nominates those people. But if they have a problem with it, they withhold their blue slip. And of course, only Democrats now, when they're chairing the Judiciary Committee, recognize that tradition. When the Republicans come in, blue slips are no longer effective.
That's exactly right. For circuit court judges especially. And so when Trump came in, The Senate got rid of blue slips. Mitch McConnell was like, we're not doing this. We are stacking the courts of appeals because Mitch McConnell, better than anyone, understands that you don't have to win elections if you can just capture the courts. They will do everything for you. And so McConnell held open, or directed Texas's senators to hold open seats on the Fifth Circuit under Obama. So when Trump came in, it wasn't just that some judges strategically retired, though they did. It was that there were vacancies awaiting Trump because Republican senators had used the blue slip process to keep those seats open and ensure that a Democratic president wouldn't be able to fill them. That's why today the Fifth Circuit has this lopsided majority of sort of, I call them judicial arsonists, judicial nihilists. They're a combination of Trump appointees and insane appointees of previous Republican presidents who have sort of banded together to be the vanguard of the new conservative right.
And I mean, it's likely, it seems to me, that if Donald Trump gets into office and has a seat or two available on the Supreme Court, the Fifth Circuit's going to have there's going to be a nominee from that circuit, right?
Yeah. So that's the other thing that's going on here. A lot of auditioning. The judges on the Fifth Circuit appointed by Trump all think they're going to be the next Supreme Court appointee under a Republican president, probably Trump 2.0. So we have people like Jim Ho, who is going out there doing this tour talking about how judge shopping is amazing. It's the best thing ever, that it's horrible that anyone would ever oppose it. He talks about abortion as this moral tragedy. He condemns like abortionists all the time. He talks about how liberals want to bring the woke constitution into effect, and we need like these brave conservative warriors for the judiciary to stop them. I mean, he's like a Fox News talking head. Similar thing with Andrew Oldham, similar thing with Kyle Duncan. These are the Trump appointees who go out there. They're the ones boycotting Columbia. They say they won't hire law students as clerks from Columbia because of the protests. They're the ones who go on TV, go to sort of student groups and shout at them and say things like, you know, you're all woke liberals. They are auditioning to get a seat under the Supreme Court. And the Supreme Court might try to send these signals to them too subtly, in my view, that they should rein it in. But to them, that just proves they're doing a good job, because universally, I think at this point, like the thought leaders of the Republican legal right think that Amy Coney Barrett, Brett Kavanaugh, and Neil Gorsuch were all mistakes and that they need to do better next time.
Right. They all think of them as like suitors, essentially.
Squishes. That's right.
Yeah. And Souter was appointed, just for 90% of you who don't remember this, was appointed by George Herbert Walker Bush. And
was it a little too much of a New England conservative for them?
Too much of a New England conservative.
We should be clear that these people are not suitors, though. Like, you know,
right? No, exactly. It's the next model, and the next model comes out. They're suitors as far as these conservatives in Texas are concerned.
Yes,
but they're completely bat crap crazy on if we use just normal, legal theory as a baseline. We've just gone from, these guys at the Fifth Circuit are basically Marjorie Taylor Greene, as far as I'm concerned. But
Alito may be Marjorie Taylor Greene as well. Like, I know we'll get to that, but they already have. Like, you're saying, Mark, that, some of these guys are Fox News judges. I saw, and I'm stealing this from somebody, I forget who tweeted it, but Alito's not a Fox News judge. He's a Newsmax judge with what, like, we're at that level already. It's just a question of more numbers on the Supreme Court who would be in lockstep with a guy like Alito, I think.
Yeah,
Yeah.
Right, sorry, before we get to Alito, let's talk about this other case out of Louisiana.
Well, I just wanted to briefly sort of wrap on the CFPB thing, if I can, because I think that's a really good point. So, like, what happens is it's these payday lenders who are challenging the CFPB because they want to put these extortionist loans out and collect all this interest and screw people over. So the housing industry, which is like not a bleeding heart industry, let's be clear, like housing people and bankers come into the Supreme Court and they're like, hey, we also don't really like the CFPB because sometimes it like fines us, but we just want to let you know that if you strike down the entire CFPB, and they told this to the Fifth Circuit too, but the Fifth Circuit didn't care. The CFPB actually provides what we call safe harbor protections for housing lenders and builders. So if you sort of follow these basic rules and you are sued and you're a housing lender, you can rely on the CFPB's protection to fight away that lawsuit, to fight away legal liability. If that is taken away, which is what would happen if the CFPB is struck down, lenders would not lend anymore, okay? Because they would be subject to endless litigation and liability for anything they do across all 50 states. There would be no federal umbrella protection. Lenders would stop lending, which means that builders would stop building, which means that both the loan and construction part of the housing industry would dry up entirely. The banking industry, of course, relies on that aspect of lending to keep its own assets going. So the banking industry would likely tip over into a collapse like 2008, which would set off almost certainly a global recession. This is not hypothetical. This is one of the key features of the CFPB that we don't talk about enough. It wasn't just protecting consumers from payday lenders and all that stuff. It was shoring up the industry so that it could have a set of rules that would prevent a collapse like '08. And so if Sam Alito and Neil Gorsuch, who are the two dissenters in this case, if they had gotten their way, if they had destroyed the CFPB, we would not be having a conversation right now. We would be running to our banks to withdraw as much money as possible to stash under our beds, because this case was quite literally a direct challenge to America's ability to maintain a functioning economy in 2024.
It's a good lesson too. If you have a cousin or a little brother who is a libertarian, ask them how we work that out between our own separate private judiciaries that would deal with lawsuits against lenders in that instance. But all right, so let's move to Louisiana. This case was about and it really makes you think like maybe there should be some type of thing like called pre-clearance with a Voting Rights Act, where maybe people couldn't mess around with gerrymandering and what. But putting that aside, this is there was back in 2022 an Obama appointee for the district court of the Middle District of Louisiana. Ruled that there was an illegal racial gerrymander. And so that's where we were in 2022. Black voters in Louisiana make up something like, 40% of voters? And there was only 1 out of 6 or 1 out of congressional districts where they were a majority. So they were clearly something was going on there that diminished Black people's voting power.
So right. And so the Supreme Court famously then issued that decision last term that sort of revived the Voting Rights Act and said, actually, racial gerrymandering is still bad. And so the district court judge there was vindicated, and the Louisiana legislature was ordered to redraw its map. So the Louisiana legislature draws a map with a second district that has a near majority of Black people. So now you have a map that looks, significantly more like the racial breakdown of the state. You've got 2 districts that are likely to elect Black representatives. So what happens then? Well, a group of conservatives then go to court and say this new map, which is ostensibly fairer and compliant with the Voting Rights Act, is actually unconstitutional under the Equal Protection Clause because the new district is just too Black. There are too many Black people receiving too much representation in this new district, so we think it has to be struck down. They are lucky enough to draw a court, and we don't have to get into the details, but it's actually a 3-judge court that 2 of the judges are Trump appointees. And the 2 Trump appointees are essentially trolling the Supreme Court here. They step in and they strike down the map. And they say, you know what? This is just too much power for Black voters. We can't accept this. This is a race-based redistricting decision. And so even though we're less than a year out from the Supreme Court saying that these kind of districts are actually required by federal law, we're going to say that this one is unconstitutional. And everybody scrambles up to the Supreme Court to get an answer because, of course, elections in Louisiana are not that far away, and they sort of need to know what maps they're going to be using.
Now, my understanding is that part of the argument, and there was an Alabama case, right, that had basically supposedly made this moot on some level, that the Supreme Court had issued on. But my understanding is that the plaintiffs here were arguing that the districts were not compact enough. That one of the elements of redistricting is sort of just like a general principle, is that you want the districts to be as compact as possible, as opposed to, I guess there's one in Louisiana that sort of like is a thin one that runs almost like the entire length of the state in the middle, almost like it was like a spine in some way. And that was the basis of their argument. And that in shooting that down, the Supreme Court is opening the door for other types of like sort of gerrymander hijinks.
So compactness is something that the Supreme Court has called a traditional factor of redistricting, but it's not an iron law, because another factor that's key is something called communities of interest. So let's say that here's a sort of micro example. There's a big Caribbean community outside of DC in one particular part of Maryland, right? The way that they have organized their lives and businesses and whatever is not into a compact district, but they're placed in the same state senatorial district that looks a little funky because they're deemed a community of interest, and the state felt that they should elect a representative who could represent their interests, or a state senator. So that is sort of the other feature that's in tension with the compactness issue. And in this case, a big fight was, well, can you sort of collect Black communities in a district and say they're communities of interest and put them in a district that looks a little bit funky? Or is the district so weird looking and so contrived that it's obviously unconstitutional? And I think this district was very different from the one in Alabama that the Supreme Court struck down. Okay, the district in Alabama that was struck down, it was like this snake that went around and sucked up every Black community that it could, and was designed to prevent Black people from living anywhere else, so that it could just be this one deeply Black district and everybody else could be in their own lily white district. The Louisiana district was different. It did have a majority Black population. It did look a little bit funky. I think that the state legislature, and I don't really want to give it to them because these were sort of cynical Republicans, but I think they were trying to follow, for the most part, the court's order, the original court's order, which was that your districts are not giving Black people representation in the congressional delegation. You have to draw another one that will boost their representation. And so these are the two poles against which all redistricting law has to go through. And it's sometimes difficult to see if one is veering too far one way or the other. Does that make sense? And
they were also trying to, I think, protect the incumbents a little bit too. So
that's right, of course. And they basically decided, they said, Louisiana's Republicans said, well, we have to get rid of one Republican incumbent. We'll pick the one we like the least and screw them over with this district. And that's what they did. But the Supreme Court has also said that that's okay. So when this was appealed up to the Supreme Court, I actually wasn't surprised to see that the 6 conservatives stepped in to restore the original map, even though it had more Black representation. In part because they have been really big on this idea that courts shouldn't change election law shortly before an election, which includes primary elections. And so I think what was going on here was, this case is not over by any means, but they stepped in, I think, because they want to make it clear that if an election is even like 8 months away, the federal courts should not be messing with maps. They should not be messing with voting rules.
Okay. And is there any there's no poisony pill type of thing that's going to come back down the road as a way to further sort of disenfranchise people?
The whole thing is poison pills. It's a giant poison pill. Either the Supreme Court now uses that principle to block progressive decisions, say that a judge says that some absentee voting restrictions are unconstitutional. The Supreme Court's going to use the same rule to block that decision and say it's too close to an election. You can't make it easier for people to vote. And then this whole case is just a mess because, like I was saying, you've got this legitimate interest in boosting Black representation in Congress and boosting, the proportional representation of Black voters. But at the same time, you've got this concern about districts that are sort of contrived to ensure that only Black that people live in them. And you've got to navigate between those two things. Republicans are really, really good at sort of scheming to make every district that's too black look like it's unconstitutional and make districts that are too white look like they're just fine.
If I'm in a Republican-dominated state, I'm just going to wait until we're 8 months out from an election to say, no more mail-in ballots, no more, we're closing half of the polling stations.
Exactly.
And then I know I'm protected, and I can do that every year.
Yep.
I can do that every cycle.
Back in the day, before
Right.
Shelby County, you couldn't. You had to run everything by the Justice Department, but now pre-clearance is over, so you can do whatever you want. And yes, the legislature can change the rules just before an election, but the judiciary can't step in to block them, even if they're patently unconstitutional.
Wonderful. Let's talk about Sam Alito. Back in the day when Scalia was still alive, we used to call Alito Scalito. And one of the hallmarks of Anthony Scalia was that he, particularly towards the end of his career, was writing his opinions more or less. It sounded like he cribbed them from right-wing talk radio.
Yes.
And it seems like Scalito is really, really worthy of the name at this point.
I would say that Sam Alito has always been worse than Scalia. Scalia had a period from like the 80s through the sort of mid-aughts when he had this strong judicial philosophy. It included things like deference to administrative agencies, by the way, that was coherent and didn't necessarily exclusively toe the Republican line, and made him an interesting jurist to watch. I think starting around 2005, he started to sort of lose his mind or get brain poisoned by Fox News. And late stage Scalia was indeed an embarrassment. But he had that phase where he had a real philosophy. Sam Alito has never had a real judicial philosophy. His only philosophy is whatever Republicans want to do, they get to do. Whatever Democrats get to do, they can't. He has always been a partisan hack. I mean, by far, he has the most partisan voting record. And so I'm not surprised that he and his wife, Martha Ann, who, by the way, is a big anti-abortion advocate and very big in the sort of conservative Catholic circles in DC that the two of them run in, I wasn't surprised that they did this flag upside down thing. I think they were entirely aware that it was a symbol for Stop the Steal. I think both of them absolutely believe the 2020 election is stolen. And I think there's a direct link between those personal views at home and Alito's own judicial writings and decisions, which are consistently attempting to call into question the integrity of the 2020 election and will probably try to call into question the 2024 election as well.
I mean, you read the New York Times article on it, and it's unambiguous, as you say, Mark, right? This is involving a dispute that he allegedly had with one of his neighbors because they had a sign that was critical of Trump that had an expletive on it, and then he responded in this manner. But Dick Durbin is now saying, NBC News reporting today, that they're not going to take up the matter and look into it as in the Senate Judiciary Committee. Why does it stop here? Is it politicking? Is it an election year? Because there should have been even more robust probes into Clarence Thomas, and now we're not even going to look into this, even though we're talking about how democracy's on the ballot. It's pretty bad politics at a base level.
And I don't even need to ask, what if Ketanji Brown Jackson's husband did something similar to this? Republicans would actively march to her house with pitchforks. There's a huge double standard here. And I think it shows that even well over a year out from the Clarence Thomas bombshell reporting by ProPublica about his billionaire benefactors and donors and all that stuff, Senate Democrats are still not playing hardball at all when it comes to the judiciary.
They're not even playing softball.
They're not even playing. They're not playing. They're not playing at all. They just packed up their toys and went home. They are scared of these justices for no good reason, right? The Democratic base is not exactly a fan of Justice Alito or Justice Thomas, but senators are for some reason terrified of the repercussions of, say, calling them before the Senate Judiciary Committee, asking a few basic questions like, do you think the 2020 election was stolen? stolen? Or did you accept a huge amount of money to rule in favor of your best friend? They are, I think, not up for the job. They are not the men and women for this moment. It's specifically the men, people like Dick Durbin, I'll say. It's hopefully a lesson for future Democratic Senates, if they exist. Don't put moderate squishes who are into conciliation in charge of the Senate Judiciary Committee. This is about the worst place that Dick Durbin could be in this Senate. If someone like Sheldon Whitehouse were in that seat, it would be a lot different. But Democrats decided they wanted to be conciliatory, and so this is the path they've chosen, the path of doing nothing.
We should also say that there was a report yesterday that that Alito sold Bud Light stock as in the wake of the I guess the hullabaloo over Dylan Mulvaney. He sold his stock and bought Coors or something, like,
yes.
By
the way, he should not be owning individual stocks, selling, whatever.
Right.
Like he and Roberts are the only ones who do that. The other ones have it in a blind trust. He and Roberts are the only ones who can be like, yes, Bud Light, they have a transgender spokeswoman on Instagram. Time for me to sell off this stock and buy some Coors. Like, the fact that that's even possible for a Supreme Court justice is in itself pretty insane.
It is amazing to me that we're not having hearings on this. I mean, it is so obvious from the reporting, and the hearings should just be like, we're just going to invite the reporters. We will invite the justices to come and defend themselves if they want. They won't come, but let's hear this story, because Clarence Thomas clearly basically said, I'm going to quit the court unless I get some type of financial support. And then all of a sudden he's introduced by Leonard Leo to a billionaire, and now they're best friends. That's a great story.
It's so real.
And I mean, romantic. I imagine, the Alito is probably not best friends with the billionaire, but there's a couple of billionaires who like him and, subsidizing his flagpoles or whatever it is. This is just, it is crazy how the Democrats, Dick Durbin in particular, and Leahy was the same, are refusing to acknowledge what's going on there. It's almost like it is the highest form of denial that I think could possibly exist. I mean, they're on the Judiciary Committee. That's what their job is.
I think that the dream of an impartial court that majestically dispenses equal justice to all is a narcotic, and these guys are still addicted to it. After all these years, they're still addicted, and it's gonna take something even bigger to shatter that. Honestly, if Bush v. Gore didn't shatter it, I don't really know what was. Maybe we just have to wait for a new generation that doesn't have the scales on their eyes. But I truly think that these senators have just grown up and built their identities around this notion that the Supreme Court is so majestic it can't be touched. And even as it corrupts itself and falls into disarray and shame, these senators are essentially propping it up through their inactions rather than launching real investigations that they have power under law to do.
I don't know what else there is to say, but I'd like 3 more Ketanji Brown Jacksons, please. And if we've got to expand the court, we expand the court. But is there anything, I mean, outside of a court expansion, the Congress theoretically, I mean, I highly unlikely, but could begin to narrow its jurisdiction.
And should. And, actually, Justice Jackson, you mentioned her. She's been writing about this since she joined the court. She's very, very strongly in favor of jurisdiction stripping, at least as a legal matter. She has written, when Congress tells the Article 3 judiciary to butt out, we have to. That is our obligation. And I think she's sending a not very subtle signal to Congress. Like, you think that the judiciary is overstepping? We'll start adding to your laws. By the way, the courts have no role in, assessing this law's legality or striking it down or intervening or whatever. I don't know whether the full court would accept that, but it's in the Constitution that Congress can jurisdiction strip. Like, it's right there. Constitution doesn't say we only have 9 justices, doesn't put a number on it. It does say that Congress can limit the jurisdiction of the Supreme Court. So it seems like it's maybe worth a shot if Congress ever gets its act together to pass major legislation again that's vulnerable to Republican attack at the Supreme Court. There has to be a line in there saying, by the way, the Supreme Court has no jurisdiction to review the constitutionality of this law. Otherwise, that law will be toast.
Mark Joseph Stern, senior writer at Slate. We'll put a link to your pieces on the cases we've talked about today. As always, a real pleasure. Thanks so much for your time today.
Thanks so much. Thanks, Sam. Thanks, Emma.
Thanks,
Bye-bye.
Mark.
Hey, folks, don't forget to hit the subscribe button and check out our daily show. We do it every day at 12 p.m. Eastern for about 2.5 hours. We even take phone calls. You should check that out.